appeal in the matter of OM and Secretary of State for the Home Department.
Mr. Brown.
May it please your lady and your lordships, I appear on behalf of the appellant in this matter. My learned friend, Miss Elliott, appears on behalf of the Secretary of State for the Home Department. By way of opening remarks, I fully accept that an argument or proposition that a mendacious or disingenuous asylum claimant should be rewarded with a grant of permission to stay in the UK, temporary or otherwise, is perhaps to many a very unattractive and unpopular argument, particularly more so in recent times given the level of political and public scrutiny given to decisions made by immigration judges in protection claims in the UK. However, that general discussion of the impact that lies in my submission lurks at the margins of this case. Those wider arguments may well be important, but are not central to the challenge in this case. The challenge in this case is specific, and it centres on whether the judge at first instance, having regard to decided country guidance in HB, and given the specific findings made on the evidence, properly assessed the risk to this appellant at the point of return to Iran. In my submission, it's important to identify the salient facts and findings made by the judge at first instance. The first is that this is an appellant who is an Iranian of Kurdish ethnicity. Second, importantly, although not decisive, he left Iran illegally in 2020. By the time of his appeal before the judge at first instance, he had been outside Iran for 3+ years. Thirdly, the narrative, or the historical narrative of events for leaving Iran were thoroughly rejected by the judge at first instance. There is and can be no challenge to those findings. Next, after arriving in the UK, it seems on the facts that the appellant was engaged in surplus political activity by posting on Facebook, but importantly, by attending a number of demonstrations. I acknowledge that the judge at first instance found that the appellant had not come to the attention of the authorities. Notwithstanding that, I think the fifth factual finding, which I say is of some importance in this case, is the fact that the judge did accept at the time of the appeal that the appellant had attended some 17 anti-regime demonstrations. But I also accept that the judge found that the motives for doing so were disingenuous and done merely to bolster a false asylum claim. My lady, my lordship, I propose to structure my submissions focusing on two issues. The first of which perhaps may be less controversial or problematic than the second. And that first issue relates to whether the judge at first instance asked and answered the question of whether it was reasonably likely that the appellant would volunteer the fact of attendance at the 17 demonstrations. The second, more controversial issue, perhaps, is whether at the point of return, if he did not disclose or volunteer the fact of attendance at the 17 demonstrations, that would still give rise to a reasonable likelihood of harm. To put it another way, is the lie about the material fact of his attendance at the 17 demonstrations likely to give rise to a reasonable risk on return, given the accepted country guidance? As to the first issue, in my submission, the central question is, would the appellant actually volunteer information about his surplus activities? In my submission, this requires the decision maker, the judge in this particular case, to explore what the appellant would in fact say. As set out at paragraph 6 of what I outlined, skeleton argument dated the 6th of January 2025, which my lady and lordships will find at page 56. My contention with the decision of the judge at first instance is that she simply did not ask and answer that crucial, central question. Having found that the appellant, in fact, on the evidence, had attended the 17 demonstrations, the judge should have asked herself in my submission was it reasonably likely that he would have to volunteer information about those accepted surplus activities? In effect, the judge should say, what would he say when asked? I say that's a legitimate question which the judge was expected to ask, and I say that perhaps it's a question which most judges dealing with assessments of claims of this nature should ask themselves when they make their findings. The legitimacy of the question, I say, has been endorsed by the Upper Tribunal, which is the expert immigration tribunal in this case, in XX, which you'll find at page 538 of the authorities bundle.
So should we turn that up now? Sorry, should we turn up that case now?
Yes, yeah. It's 538. Particular paragraph 98. There's a question of.
Sorry, I missed the page number.
Page 53,
Thank you very
my
much.
lady. And it's specifically,
Sorry, hang on. 98.
and specifically what the tribunal set out with regard to whether a person can be expected not to volunteer the fact of, in that particular case, it was Facebook. When I say parallels can be drawn, same question should have been asked, simply not being asked. I submit that the judge
So
at first,
should we read paragraph 98? Or would it be best if we read on a little bit further?
to 101 I was going to take you to. Yes.
Oh, I see. Yes, I see.
Yes, I was
Yes,
going to take
sorry,
to
yes.
101.
Should we look at 98 to 101 and then hear your submissions on them?
My lord, if I
102,
might
102.
crave your indulgence to go to 102 as my
102,
mention
yes.
said.
We'll go to 102 as well. Yeah, thank you very much.
I would submit that that central question is important when looking at what we know from HB is the necessity for a hair trigger assessment to that particular risk upon return. I say that the judge, having made the positive findings that she did, should have asked that question for herself and answered it. The Upper Tribunal and the decision of Judge Hoffman in determining whether there was an error of law fell into similar error and didn't ask and answer that question. It's my submission that that omission is important in the context of this case, and I say that recognising that this court in S, again, which you'll find at the authorities 147,
Which we should turn up.
there's a particular paragraph 23. I say, although there are similarities in terms of facts and in S, it's important in my submission that the distinction is that this court was satisfied in S that the court below had asked and answered the question, and they proceeded on the basis that the appellant would not volunteer that information, and as a result would not be at risk. I draw that proposition from that particular paragraph, and what I say is that the judge needed to ask the relevant question and give adequate reasons for any conclusion. It may well be that had she done so, those reasons for concluding that the appellant would not volunteer information may well be subject to an adequacy of reasons challenge. We simply don't know. I say that the failure by the judge to approach the assessment of risk in that manner impacts on the hair trigger assessment approach suggested in HB. And I would submit that it remains in doubt with regard to that omission, whether the judge at first instance, had she answered the question, the results would have necessarily been the same. So I say that for those reasons, that first ground should lead the court to say that the decision of First Tier Tribunal is unsafe. I turn next to what I describe as issue 2. Namely, would there still be a risk to the appellant if he did not volunteer the information about his attendance at the 17 demonstrations? What I'm suggesting is that, well, in effect, what would be the impact of that lie to this specific appellant on return to Iran? I would openly and readily accept that this is perhaps a more difficult and controversial argument insofar as it relates to Iranian Kurdish asylum seekers. And it would be wrong for me to suggest that an appellant cannot be expected to lie about a political opinion that he or she doesn't genuinely hold. But I say in this case that the position for the appellant is that he might still be presented with a risk of harm if he did not lie or did not volunteer the truth. The focus in the submission must be on the speculative risk of what the likely reaction of the Iranian authorities is to that lie or that failure to volunteer the truth. In my submission, a number of factors potentially come into play. The first is the length of time an appellant has been outside Iran. second is information generally about the activities of Iranian Kurds in the diaspora in the UK. Third is the
Hang
intense
on, sorry.
information generally about the activities of the Iranian Kurds. So in the diaspora of Iranian Kurds in the UK.
Yeah.
The third is the intensity of any inquiry at the point of return. And the fourth is an assessment of whether, in reality, a position of neutrality is likely to be inferred by the Iranian authorities. And lady in my lordship, this was an appellant who, at the time of the hearing, as I indicated earlier, had been in Iran for over 3 years. Whilst in the UK, he had spent some time in the Iranian Kurdish diaspora. What we do know, I think, from decided authority, I don't think this is particularly controversial, is that those Iranian Kurds facing return to Iran on an involuntary basis are likely to face questions. If authority is needed for that, you'll find that, for example, in the case of BA demonstrators, at pages 235 to 237.
Shall we just see what they say?
We just set out the background evidence relating to what happens.
And sorry, the paragraphs you were referring us to were the totality were from.
Yes, 235 to 237. Yes, it was really. Yeah, it's really just the background evidence. I didn't think it was particularly controversial.
Yes, I see.
In the what happens, and again, you'll find similar observations in the case of SSH, at page 63, specifically paragraph 9. And also in the case of PS, specifically at page 495, paragraph 114.
Paragraph.
114 of PS.
Sorry, let me just turn that up.
Because I didn't think it's, well, I didn't think it was particularly important to say, because I didn't think these general propositions were controversial.
And I bet you're right, but just so I understand,
Yes.
the so what is the last word on this aspect in the authorities? I'm not sure, I don't think the authorities are in the bundle in chronological order, are they? So which is the last in the line that would tell us what the thinking is?
I think it's SSH was last in time. No, PS was, PS, paragraph 114. Yeah.
Yes.
My lords, HB Kurds is the last word on Kurdish returnees who are not Christians. PS is just about returnees who are Christians. So if you want the last word, I'd advise looking at HB. I will obviously take you to there in due course. But
Yes, I see.
On this point, when we were looking at the case of XX, and you took us to page 538 onwards, and we were asked to read paragraph 102, which goes over from 539 to 540. There's reference in there, I noted, to whether the government has well-established methods of questioning, and it says in the Iranian state's case, these are well documented and therefore predictable.
Yes.
And I wondered whether there was anything that told us a bit more about that.
No, I couldn't specifically take it.
Mr. Brown, can I ask you this? Does your submission effectively amount to saying that any Iranian of Kurdish ethnic origins who has been in the UK for a number of years qualifies as a refugee?
I perhaps predicted that this court would pose that question, and I am fully conscious of the possibility of a floodgates argument being advanced to counter such an argument.
Forgive me for interrupting you, Mr. Brown. Speaking for myself, I never worry about floodgate arguments because either the law does require a certain outcome or it doesn't. So,
Well,
I'd just be interested to know if
in
that's
simple
your
terms, yes.
if that's your submission.
In simple terms, yes.
Yeah.
If on the facts as found, if this argument is correct, then it may, in every case where it can be established that there is a real risk at the point of return. So I would say my answer to your question, my lord, it is yes.
But is there any authority to date which supports that?
I couldn't identify such an authority.
I may be wrong, because I genuinely like your assistance, and indeed Miss Elliott's assistance in due course. But my impression from having read the authorities that you've both kindly shown us in the agreed bundle is that to date the cases appear to envisage a highly fact-specific inquiry in each case. So if that's the right approach, and I think you're indicating that that is what the authorities say,
Yes.
that would tend to suggest that there isn't any general principle,
No.
and that one just has to look at each case on
Yes,
its facts.
and that's why in opening I said it's a fact-specific inquiry, and it relates to the facts as found positively in this case that the defendant had attended not just one demonstration, but 17 demonstrations.
Yeah, the first way in which you've articulated your submission, I readily understand. I'm not saying I agree with it, but I understand how you put it. You basically you say it's a fact-specific inquiry, and you look at the reasoning of the FTT in this case. The judge failed to ask what you describe as the crucial question.
Yes.
Error of law.
Yes.
End of. Really.
Yes, and it may well be if the matter is remitted back to the First Tier Tribunal, the arguments can be developed as to whether the volunteering of that information or not would give rise for a judge to assess whether or not there would be a risk have regard to the argument which I've advanced.
Yeah, the first way of putting it, I understand. The second way, I have to confess, speaking for myself only, I have more difficulty with because it seems to be tantamount to saying that it doesn't really matter what happens in the interrogation at Tehran airport because effectively, if you're an Iranian of Kurdish ethnic origins who has been in the UK for a number of years, then that's tantamount to qualifying as a refugee.
The difficulty, my lord, in answering the question is that there is a lack of empirical evidence which I can point to say, well, this is what happens if an Iranian of Kurdish origin is returned involuntarily to the Tehran airport, by way of example. The evidence is simply not there. And the Secretary of State could perhaps explain why the many Iranian Kurds who have had their claims failed have not been returned. It would be useful to know what happened, but that simply hasn't happened. But what I say is that on that fact-specific inquiry, when pressed, what is this appellant likely to say?
Is that your point really, that on your second point, you still rely on the fact that he did in fact take part in a number of demonstrations?
That's not a lie.
Yes.
Yeah, that's the difficulty in the case. That's not, the judge may have rejected the evidence of the appellant's demonstration, but importantly, she didn't. And it's not one demonstration, it's 17 demonstrations.
So
and
effectively saying he may not volunteer it, but the fact he's been in the country will lead to him being pressed. Is that?
Yes.
The
I mean, the difficulty, as I see it, the appellant could maintain the lie, but equally, when pressed, he could reveal the truth of the attendance at 17 demonstrations. And I say that in terms of assessing on the lower standard risk, the sheer number of attendances, albeit in bad faith, in order to bolster a false asylum claim, is in my submission likely to still raise a suspicion that he holds a political view adverse to the controlling authorities in Iran.
So can I just understand exactly what the submission is?
Yeah.
So suppose the first tier judge had found in terms that the appellant was unlikely to reveal his attendance at any demonstration or any Facebook posting. How would the second submission apply in those circumstances?
Well, it depends on the reason why the judge would come to that conclusion. I suppose Judge Power in this case could have said, well, I've asked myself that question, and I don't believe he would reveal his activities, and then give reasons why not. If she had answered the question appropriately, it may well be that that decision wouldn't be necessary to challenge. But the difficulty, as I see it, in cases of this type, decision makers have to, in the context of what we know about the Iranian regime, ask themselves how likely is it that the Iranian authorities will believe an appellant if he says he didn't take part in any anti-regime activities or demonstrations.
So just try to understand what the second argument adds. You say, well, even supposing that the first tier had found that the appellant would not volunteer any information, the Iranian authorities might not believe it anyway.
Yeah, and because he's a Kurd, and because of the length of time and the factors which I mentioned earlier on, in my submissions, it's really important in cases of this type, bearing in mind what's at risk. Is it likely that the Iranian authorities will believe what in effect is a lie, that they didn't take part? Now, in my submission, that may well be the crux of the second matter. It may well be an unattractive argument, but it's an argument which I'd have to advance on behalf of this particular appellant, particularly given the specific facts as found. And particularly given what HB informs us as to the level of suspicion which is aroused when an Iranian of Kurdish ethnicity is returned.
And I mean, everything, as you were discussing with my lord, might be said to be fact specific, but are these submissions consistent with XX?
Yeah, as I understand the position, yeah. I'm not sure what my learned friend may say in response.
And I've forgotten the detail of XX, but they rather say there, don't they, that there isn't necessarily a risk. The Iranian authorities won't know about Facebook postings. They can be shut down.
Well, I understand that's specific to, but I'm saying it's the intensity of the inquiry in my submission which is important in cases such as this.
And is there a reason for it being more intensive here than it would be in XX?
I've been perhaps taken to a particular paragraph of
And the trouble is, I'm going to struggle with that because I looked at it and have a general impression of what they said. But so they go through, starting at page 536, looking at what Facebook material would be visible, and they say in 97, when an Iranian national returns to Iran, the fact of not having a Facebook account, having deleted an account, won't raise suspicions. And then 121, Iranian authorities can't monitor Facebook accounts. 1, 2, 3 won't raise suspicions. I mean, is all this not inconsistent with your broader thesis? Because they seem to be proceeding on the basis that actually, in these sorts of circumstances, there isn't really a risk.
Again, my interpretation of those observations was specifically relating to the Facebook activity. It's really, as I said, and I take you back to the fact specifics, it's the attendance of the demonstrations.
But in XX, the Facebook activity related to attendance at demonstrations, posting pictures.
So I don't, in those circumstances, seem to push that particular point. And I did perhaps identify that second issue was slightly more problematic than the first.
Yeah.
Yeah. In essence, if I can take you to Court Bundle 27, so the court is with me about the assessment applying the HB here to the approach. And I say that what I set out to paragraph 3 of those outline arguments are relevant to that point. And it may well be a very broad and far-reaching submission to make. But in my submission, for matters which I set out earlier, this particular appellant, having regard to the fact of illegal exit, having regard to the number of years he'd spent out of Iran.
Why does the number of years matter?
It is a question of whether or not the Iranian authorities will infer something from that period. Again, I can't point necessarily, but I'm saying is it likely that that factor will play any part in the inquiry, in the intensity of the inquiry?
And I'm probably being obtuse, but why will they worry more about somebody who's been out of Iran for a long time than someone who's
Because
been out of Iran for a short
for
time?
a Kurd, it's more likely in those circumstances that they would have been part of the Iranian Kurd diaspora. Yeah. And from what we know, the majority of those in the diaspora form a view which is anti to the controlling state in Iran.
I mean, suppose somebody simply left for economic reasons. Then they'd be just as. I don't know that the length of time outside of Iran would.
If the simple fact was someone left for economic reasons and didn't take part in any way in the Kurdish diaspora, then there wouldn't be a difficulty. But I think there is a particular difficulty when it comes to the assessment of involuntary returnees who are Kurdish, who've left illegally, and who, on the facts, have actually taken part in demonstrations. Well, that's the way in which I would respond to that inquiry.
But isn't this the kind of question that is really a matter for the tribunals?
Yes.
And in particular for the Upper Tribunal, when it gives country guidance, as in this area, in the context of Iran,
Yes.
as we can see from the bundle of authorities,
Yes.
there are lots of country guidance cases
Yes.
where that expert tribunal, gathering all the evidence in one place,
Yes.
is able to promulgate guidance on what
My
happens.
lord, I entirely agree with you, and it may well be that this court is not with me on that second issue. But if the expert tribunal is to be taken as a tribunal which provides authoritative guidance, the guidance which they give about asking the right questions with issue 1 is important.
Yeah, well, that I understand, and although you haven't taken us to it, I think you do place weight on the guidance given in HB,
Yes.
because those numbered paragraphs in the
Yes.
head note, the 10 paragraphs,
Yes.
I think you would say each of them is very important.
Very important, and I say for the reason that, but even leaving aside that, I think without a judge at first instance asking that central question, I say the HB assessment simply can't be made. Hence the reason why I indicated earlier that it may well be the strength of the challenge in this case relates to the first issue, and it perhaps needs then to be resolved at some later issue as to whether these wider arguments can and probably be advanced before another First Tier Tribunal or the Upper Tribunal.
If you succeed on your appeal, and I should not be taken
No.
to imply
Yes.
one way or the other, I don't know what the outcome will be. But if you should succeed on your appeal, what's the most you can realistically
Most I
ask the
can
court to
realistically
do?
is a discussion as to what preserved findings, if any.
So you would accept remittal
Yes.
to the FTT,
Yes.
but then you want to go on to say there might be some findings of fact preserved. Is that what you're saying?
Well, I said there'd have to be a discussion as
Oh,
to
I
whether
see. I
there-
see.
there
Sorry,
would
I thought
need
you
to
meant
be,
discussing amongst yourself,
or
not
whether because
Right. I
because
see.
because does success on issue one mean that what the First Tier Tribunal found regarding other matters fall away? I'd like that to be the case, but whether or not it's appropriate to do so is a discussion which perhaps we may need to have. But for those reasons, as I said, the challenge is a fairly narrow one, and I say the failure perhaps by the judge to do what I say regarding issue one means that the whole hair trigger assessment has simply not been done properly for those reasons. It's simply not safe to return this specific appellant to Iran. My lady and my lordships, unless you have any further specific questions, those are submissions I'll make to you.
That's very helpful. Thank you very much. Miss Elliott.
My lord, I'm grateful. In terms of the facts, I think my learned friend very fairly took you through the key facts in terms of OM's case and identified those which were properly not the subject of appeal. In fact, none of the findings of fact are appealed, so I won't trouble you with those. I do think, however, that the court would benefit from actually looking at the FTT's decision to see what it did in fact decide, and that's in the core bundle at tab 24, and that is page 114. So the first key finding is that the FTT was not satisfied that OM was a genuine political activist in Iran or in the UK, or that he would wish to engage in political activism in Iran. In respect of his account of the activities in Iran, and Model, I don't invite you to go to these paragraphs, but the references are paragraph 19, which is on page 117, and 24, which is on 119. So he dismissed the account that there'd been any political engagement before departure from Iran. And then in respect to the UK, it was found at paragraphs 20 and 24, and again, my lord, please don't turn them up, that's at 118 and 119. It was found that he had not had any genuine affiliation with the Kamala party, that's the Kurdish party, while in the UK. And then paragraphs 36 to 38, which we'll look at in a moment, on 122 to 123, it was expressly found that the surplus activity was not genuine but was contrived to bolster his claim. And I dwell on this because it establishes the baseline for this court that OM was not found to be a person who had acted on genuinely held political beliefs but out of a desire to avoid removal from the UK. Second sort of theme of findings was in respect of attendance at anti-government protests in the UK. And my learned friend is correct that it wasn't disputed by the Secretary of State that he had attended 17 anti-government demonstrations between December 2020 and November 2023. The FTT found that there was no evidence that OM's attendance at these demonstrations had come to the attention of the Iranian authorities because he'd been, for example, because he'd been in a small group or he'd taken a leading role, or that attendance had been the subject of any publicity. It held that it appeared that OM had attended the protest just long enough to have his photo taken as evidence in support of his protection claim and had then left. And those paragraphs are 28, which is on page 120, and 36, 122. It was noted by the FTT there was no evidence he'd attended any further demonstrations after November 2023, which was the same month that the Secretary of State refused his asylum claim. So he didn't continue to engage in any surplus activities after he'd had a refusal decision, which was then the subject of appeal. And that's FTT paragraph 37E. Now, the issue of attendance at demonstrations is the subject of specific country guidance in BA demonstrators, which I will come to shortly. Now, that was before the FTT. It wasn't mentioned in the decision, but my learned friend doesn't take a point that it wasn't considered by the judge in reaching her decision. Then in respect of anti-government Facebook posts, the FTT expressly took into account the XXPJAC case that has been discussed quite a bit this morning, and that's at FTT paragraph 29 on page 120. Now, that is the most recent country guidance for this cohort of individuals.
Which paragraph was that?
So that is paragraph 29, my lord, on page 120.
XX.
Yes, and we'll be looking in a bit more detail at those paragraphs that followed now. So as I was saying, the XX is the most recent country guidance case for Iranian Kurds who are making their asylum claim on the basis of surplus activities in the UK. And very importantly, the Upper Tribunal, in handing down its decision in XX, reviewed all the previous country guidance decisions for Iranian Kurds going all the way back to HB. So if there is any suggestion that any of those are outdated, I would suggest that that is ill-founded because they are not left hanging in the wind. They are regularly reviewed when any case involving persons in these cohorts come up for consideration, as happened in XX. Now, having open these paragraphs on Facebook activity and turning over the page to look at paragraph 30, you see there that the tribunal found that there was no evidence that OM's Facebook account was live and or viewable by the public for any length of time, i.e. beyond the time needed to take a screenshot of a post for the purposes of bolstering his protection claim, or that his post had been shared outside of his account. And that's the subject of detailed findings from 30 to 32 on that page. And it was expressly found in paragraph 36, which is again over the page 122, that there was no evidence that the Facebook post had come to the attention of the Iranian authorities. Now, my learned friend says that the judge didn't consider then, having found that the Iranian authorities would have no knowledge at all of the surplus activities, either demonstrations or Facebook, did not then ask herself what the appellant OM was likely to do on return to Iran. And it's accepted that that is something that had to be asked. Well, the answer to that is in paragraph 37, apologies, at the bottom of that. And I'd invite the court to read that paragraph in full. And continuing on to paragraph 38.
There's no finding there that he would delete his Facebook.
Well, she says, I'm not satisfied that he's genuinely politically motivated and wish to protest. And the Secretary of State's position is that her saying that she does not find his response to the question in cross-examination that he would not delete it credible.
That doesn't, on the face of it, quite deal with the point, does it? So in response to a question, the appellant confirmed that he would keep supporting the Kurdish cause if returned to Iran.
Emphasis on keep supporting. So he's saying, I've always supported them and I'll keep supporting them. and then she goes to say, I'm not satisfied about that answer because she doesn't accept that he's given a credible account of his political activity.
You say you can infer from that.
Yes.
that he deleted
Yes.
Facebook.
Yes, I see.
A specialist tribunal having regard to XXPJAC, which expressly says you need to ask this question.
Yeah.
So that is, in the Secretary of State submission, a complete answer to Muller and Friends submissions on ground one, that there wasn't the question asked.
Well, can we just pause there, please? As I understand Mr. Brown's central submission, it is this. Let's suppose the Facebook account is deleted. And let's suppose that this man is returned. He's at
Yes.
Tehran airport
Yes.
and he's asked to come to one side to an interrogation room so they can
Yes.
ask him questions.
Yes.
All of that, at least, do you accept, seems to be entirely plausible in the light of country guidance cases?
And was considered in excess expressly, my lord, yes.
So there's nothing inherently implausible about that scenario arising?
No.
Right, okay. So then suppose that in the interrogation they ask, did you go on political demonstrations in the UK against the Iranian regime? And what Mr. Brown says is, even if it was for a contrived reason, it is a fact that he did go,
Yes.
and the tribunal has so found.
Yes.
And so once that's been accepted, and suppose he gives that answer, then what's going to happen to him?
So, my lord, I can only say, because I'm not entitled to speculate about what will happen in these interrogations, and nor is Mr. Brown, that this is the specific scenario that XX considers. It considers this with respect to Kurdish Iranians, and it does not find that Mr. Brown's client's facts are enough.
Where do we find that in XX, please?
So I was going to address you in XX a bit later, but I'll come on to it now. my lady.
Just before you go to XX, can I try disentangling different things? XX says it's legitimate to ask what somebody would actually do in a hypothetical interrogation. Is that correct?
Yes, it looks at what would likely happen to someone in the position of Mr. Brown's client
Now,
if
as
they
I-
deleted their account.
As I understand Mr. Brown's first submission, he says, well, the trouble is that the first tier judge didn't actually ask that question.
Yes.
Now, can you find any indication in the first tier decision that that question was asked?
So those paragraphs that I've addressed, taken you to, are where that is dealt with in the FTT's judgment in my submission. And I accept that she doesn't expressly say, I have asked myself the question that so and so, such and such, and my answer is this. But you can clearly understand from those paragraphs, 37 and 38, and the fact that she had XX before her and expressly considered it in some detail in the previous parts of the FTT decision, that she considered this issue and found that it wasn't credible for him to say, I won't delete it / I'll volunteer these activities. And XX expressly found, and she's obviously following XX, that it's not enough to be a Kurdish Iranian failed asylum seeker returned to Iran to have engaged in surplus activities, whether demonstrations or Facebook posts, if the Iranian authorities don't already know about them. And she went into a lot of detail on the knowledge point, and she found that they wouldn't have known about them. And following XX, which this court has already approved in S, she didn't need to go any further and speculate.
So it's paragraphs 37 and 38, and you say the inference is there that of a finding that he
Yes.
will delete the Facebook and he won't volunteer
Yes,
his act.
yes, my lady. And obviously, those paragraphs have to be read in the context of all the previous discussion in those XX paragraphs, which I took you to, and we can look at again. That's paragraphs 29 onwards.
29,
Yes,
relating to Facebook activity.
yes. the key finding at the end of her sort of X analysis, I mean, the 37 and 38 are part of it, but 36 on page 122, there's no evidence. I've not accepted the appellant's account of undertaking work for the Kamala Party in Iran or in the UK, nor that the appellant's Facebook activity and attendance at demonstrations has come to the attention of the authorities in Iran. There's no evidence that the appellant's Facebook account has been the subject of surveillance, and no evidence that he's received threats as a result of his surplus activity. There is no evidence that the appellant would be of significant adverse interest to the Iranian authorities. Now, that's important because XX establishes that the Iranian authorities, as much as they might talk big, are actually only technically able to monitor the live Facebook accounts of people that they're already interested in. And OM was not such a person, and that is an unchallenged finding of fact in the FTT. And then she goes on, I'm not satisfied that there are other risk factors which in combination with the appellant's Kurdish ethnicity would create a risk of persecution or Article 3 ill treatment. And obviously,
Sorry, that's paragraph.
that's paragraph 36, my lady, on page 122.
So that all deals with the case law.
Yes.
You mentioned some other paragraphs which you went through fairly rapidly. It's not criticism, but just make sure I've noted them correctly. I've got paragraphs 19, 24 and 28.
So the findings section starts at paragraph 14, but that first section is largely about the situation in Iran, which is much less relevant because of the findings. So it really is from paragraph 25 to the end,
Yes.
25 to the start of the what I call the XX section, that is about attendance at demonstrations. And although it's not mentioned in the FTT decision, and my learned friend doesn't take a point on it, that is demonstrations specifically are dealt with in the case of BA demonstrators, and that is surplus activities. And again, the key is there evidence to suggest that those activities have come to the attention of the Iranian authorities? And it sets out the various factors that you would look at. For example, is there evidence that someone's been filmed? Were they particularly significant? Say, were they standing up on a platform with a megaphone going, down with Iran?
So that's a clear finding of fact in that section,
Yes.
that it wouldn't have come to the
Yes.
authorities already. Just remind me, is there anything that deals specifically with the point about if questioned at the airport? what
So-
you would say?
So that is only dealt with in 37, and it's you've already looked at it, my lady. But in response to a question from the respondent's representative, so the Home Office representative is obviously asking that question.
Well, you say that
because-
question, which question?
So the question of question from representative, the appellant confirmed that he would keep supporting the Kurdish cause if returned to Iran. So obviously, would you continue to support the Kamala Party if you return to Iran, or you wouldn't? Would you support the Kamala Party if you return to Iran?
That's a completely different question, isn't it?
Yeah, but you have, my lady, HJ says, this is the Supreme Court case which talks about risk based on assessment of what someone would do on return.
Yeah.
What you have to ask is what would they do? How would they actually act if confronted with a situation where they might be at risk of persecution? In that case, it was because of someone's sexual orientation. In this case, it is engagement in political activity. You have to ask the question, what would they do? And you would have to ask OM, and he clearly was asked in this case, well, what would you do if you
Well-
went back? And he said, I'd keep supporting the Kurdish cause if returned to Iran, and the FTT didn't accept
Sorry, but that is a different question. So there's a clear finding in relation to that. Certainly something that can be inferred that he wouldn't keep supporting the Kurdish political view. But what about the question, if asked, have you taken part in political activity?
There is nothing in the FTT decision which asks the question, if he was sat down with interrogators, what would he say? And my Secretary of State's position is because this individual didn't get that far in the country. The country guidance says the first question to ask is, was there knowledge of the activities? And I'll take you through them, but just by way of overview, it's not enough to be a Kurd. It's not enough to be someone who is an asylum seeker. It's not enough, despite what my learned friend suggested, to have been away from the Iran for a number of years. There has to be knowledge by the Iranian authorities of your political activity. Doesn't matter whether it's real or not, but they have to know
Before the question
is asked. Yes. So
And that may well be crucial, but just coming back for a moment to the first year decision and this question of what you can infer from it. In paragraph 29, as you mentioned, the first tier refers to various paragraphs of XX. The judge doesn't refer to the paragraphs at 98 to 102 dealing with asking the question, and nor, in fact, does the judge refer to paragraph 129, where again there's sort of allusion to asking the question. So the judge gets as far as 128, but she doesn't then refer to 129, and she certainly doesn't go into 98 to 102.
my lord, my answer to that would be, well, first of all, my learned friend isn't complaining about that, and it wasn't part of the grounds of appeal, but is really what I say in my skeleton argument, paragraph 19.1, which is the level of reasons that are required from the specialist tribunal on matters of immigration, and that is taken from the case of our Iran. So need not refer to every point raised. If the reasons do not expressly deal with a particular argument, but it can be seen from the reasons given that there are grounds on which the decision maker would have been entitled to reject it, the appellate body should assume that the decision maker acted on those grounds, and the inference of error of law should not readily be drawn on appeal, absent a convincing reason to the contrary.
And I see all that, and I see the potential force of that. But at the same time, if we're thinking about whether the judge asked herself what this individual would say if interrogated in Iran, it's that much harder to infer that the judge asked and implicitly answered that question if, when she refers to XX, she doesn't refer to those bits of the decision.
My lord, yes, I have to accept that.
Yeah.
But I'd say my stronger point, if you don't feel that that those paragraphs went far enough, is that she asked the questions that the country guidance required her to ask,
Yes.
and on the country guidance, she didn't need to go that far. My lord, going back to into staying in the FTT decision rather, and dealing with a point that was really the core of my learned friend's ground of appeal, but which he didn't refer to at all, which is this issue of HB Kurds and Head Note 10, and I'm going to deal with that very briefly. If you look at paragraph 34 of the FTT decision on page 122, you will see that the FTT considered a submission on behalf of OM that deletion of the appellant's Facebook account would not remove the risks to the appellant, as even low-level protest activity combined with his Kurdish ethnicity puts the appellant at risk of persecution or Article 3 ill treatment. And that was argued, as it is put in the skeleton argument anyway before this court, with reference to the HB Kurds country guidance case. And you'll see in paragraph 35, the judge says she's carefully considered the submissions on behalf of OM and the CG decision in Kurds, and she notes various head notes. She doesn't note head note 10, and the reason that it doesn't fall down on that, if you set aside sort of the Iran thing about not needing to refer to every head note under the sun, etc., is because the judge didn't need to think about head note 10, because that's the hair trigger sort of interview situation point, and it only arises, that hair trigger moment, where there is knowledge on the part of the Iranian authorities about facts that would make someone particularly interesting to them, like knowledge of surplus activity. And you'll see that in 36, which we've already looked at, this is the judge's findings, which show that he didn't get into that situation because there was no evidence that his surplus activities had been discovered, and he could reasonably be expected to delete his account and not volunteer information about his surplus activities on questioning. And you'll see, just looking at head note 9, actually, that is referred to.
You're looking at HB now.
We will be shortly, my lord. I'm going to be moving on, I
Sorry.
promise.
At the moment, you're still in the FTT.
Yes, but if you look at in paragraph 35, it quotes the head notes of HB Kurds, and if you look in head note 9, so that's the last paragraph in italics. Even low-level political activity or activity that is perceived to be political, such as leaflets or sporting Kurdish rights, if discovered, involves the same risk of persecution. And then it goes on to be the fact-specific assessment point.
I think referring to paragraph 36, you've just told us that there was a finding that he could be expected not to volunteer his activities, but
Sorry, that's me going on then to 37. And my lady, I accept that you don't necessarily agree that the findings made in that paragraph are sufficient. It doesn't say that would not volunteer information, but that is what I say that you can take from. Yes, exactly. Okay, and it was on the basis of those findings that the asylum case failed. And my lord, I won't take you to the UT decision because I know you're all eager to get into the country guidance cases. It's just the one paragraph, 11 at CB 1711. It was felt that there wasn't an error, and in any event, a failure to refer to head note 10 was not material, because even if the judge had looked at it, it would have been the same outcome. So then, moving on to country guidance. And I'm going to take this court through the sort of decision-making pathway for Iran return cases, which raise factors like OMs, and these were approved recently by the court in the 2024 case of S, which we'll be looking at later. Now, I think the first point to make is that, yes, all asylum claims are obviously determined on their facts, that's not disputed, but the point of country guidance decisions is that they are the moment when the court gets to assess not the specific facts of an individual, but the specific facts of the country of return. So yes, fact-specific assessments. Yes, you don't always have to do what the country guidance says you need to do, because the facts of a particular case might justify different treatment, but they are the lodestar for the majority of cases. Their purpose is to promote consistency of decision-making. And if you think that something's outdated, or you think that there needs to be a consideration of evidence about what happens, for example, in interrogation rooms in a Tehran airport, they are the forum for that, and not this court. It's also important that country guidance decisions are read together, because the UT's approach to the cases is refined over time, and that principle was confirmed in the Iran case in this court, which is the separate authority that my solicitors filed with you, which I won't take you to, but that's paragraph 26 on page 648 of that law report. So the first factor under consideration in cases like this is Kurdish ethnicity, and it's the factor my learned friend focused on. Now, it's well settled that the fact of Kurdish ethnicity in and of itself is not enough to get an appellant home on Article 3 grounds, and that's per the HB Kurds case, which is at AB tab 11. And it's a detailed decision, as all country guidance decisions necessarily are. So it's page 389, and my lady, thank you for the information about the tabs. And if you go to page 390, using the useful headnotes, the key headnotes for the purposes of that proposition are headnotes 4 and 5. So it's not enough to go back as an Iranian of Kurdish ethnicity, even if you exited illegally. That's not enough. but it is sort of a bedrock onto which other risk factors might build up that get you into Article 3 territory. And the rest of the parts of HB sort of talk then about specific risk factors which the tribunal had considered: residence in the KRI, so an area of particular tension, political groups in Iran, and then it goes on to the headnotes in 8, 9 and 10, which have been the subject of a lot of quotation. The risk is basically, if you're a Kurd and you have been involved in political activities, that is an obvious risk factor. And then it talks in 8 about what activities might be perceived as political. And I should pause and say here that in the ground of appeal, it was said, well, the judge didn't refer to headnote 8, and that's also somehow an error. I mean, it wasn't necessary to refer to it because there was no doubt that the surplus activities here were political. Attending demonstrations and posting on Facebook is undoubtedly political. And then we have headnote 9, which we looked at when it was quoted in the FTT decision. And then we have that headnote 10, which is where the hair trigger language my learned friend use comes from. And again, I paused to underline the words "to those suspected of or perceived to be involved in Kurdish political activities." Now, it follows from reading all those headnotes together that the very fact of being a Kurdish Iranian is not enough to put you into the category of someone suspected of or perceived to be involved in political activity. There has to be something more. So the second factor in OM's case, which my learned friend relies on, is illegal exit. And as you'll have seen from HB Kurds, that, again, even in combination with Kurdish ethnicity, is not enough. If you weren't already the subject of adverse government interests before you left Iran, which OM was not in this case. And that was dealt with as well as in HB. It was also dealt with in the country guidance case of SS and HR. That is in the authorities bundle at tab 10. It's basically duplicative of what is said in HB, so I won't take the court there. But the paragraph references for that are in paragraph 1.5.1 of my skeleton for the court's reference. And I should say that this court, rather the Court of Appeal, in the S case at paragraphs 52 and 53, which is at, I won't invite the court to turn it up, authorities bundle page 157, expressly approved that.
Can we just look at that? Because
Yes, that's my lord, of course.
This court's decisions are binding.
Indeed.
On this court.
Yes.
So that might be
Yes.
important. Where is it?
So it's in 157, on 157.
And which paragraph?
So 52,
Yes, that's right.
which is a recitation of HB. And then, my lord, I think it will save time now and later if this court reads from 52 on 157 to 56, which is on 159.
Thank you. you submit that, in essence, the present case is on all fours with S?
Yes. And I would point out, in respect of length of time, that the appellant in S had been out of Iran for 4 years by the time of the Court of Appeal's decision, and several years, I think 2 or 3 years, by the time of the FTT decision. So that is not a distinguishing factor to the extent my learned friend might say that it is.
In S, paragraph 54 really sets out the key factual findings that underpin
Yes.
that decision. The factual findings in this case are not as clearly expressed,
Yes. My lady, I would have to accept that.
but you say that they are there. In
Yes.
the first
Yes, my lady, yes. Yes.
So in 54, we see that in that case the judge had posed the question what the appellant would or could reasonably be expected to say when questioned by the Iranian authorities. And then in 56, at the end, we see that the appellant wasn't in a position where he would have to prove his political loyalty. Rather, it would be a situation in which the appellant would not be required to volunteer information.
Yes.
So that rather suggests that it's been found that he's not going to be asked the question.
No, my lord, the reason that she's talking about in that last sentence about would not have to prove his political loyalty is that she's distinguishing the facts of returnees to Iran from the facts of returnees to Zimbabwe, which is the case that she's talking about in 55, and 55 and 56 is sort of the consideration of that. So in the RT case, which is in the bundle, the House of Lords was looking at the application of the HJ principle in cases where it wasn't a question of someone being asked to conceal political beliefs, but to avow political loyalty, in that case to the ZANU PF party. RT's in the authorities bundle at 2. And in that situation, what would happen is that militias were roaming around the country, effectively holding up individuals they didn't like and saying, prove that you support ZANU PF. So that is why she's talking about not in a position to prove political loyalty. And
Followed that bit, but
Yeah.
what about the last 1.5 lines?
would not be required to volunteer information about his activities in the UK. So that is the Court of Appeal looking at what XX says about why, which we're going to come on to, I promise, about why the deletion of Facebook accounts is enough to get you past the Article 3 risk.
It takes us back to paragraph 34. So the Upper Tribunal judge did accept the weekly work and she questioned on entries into Iran and posed the question what the appellant would or could reasonably be expected to say when questioned, and then that's her answer. He wouldn't be expected to volunteer.
Yeah, going back to paragraph 34 of the Court of Appeal's decision on 151, you see counsel for the appellant actually making effectively the same submission that Mr. Brown is making under his ground 2. Paragraph 21 that's quoted there, which I've just asked the court to read. And in fact, if the court could read all the way through the quoted italic section onto the next page, I'd be grateful.
explicit matters. I'm still a bit confused about that last bit of 56, where it seems to say that it was a case where the appellant wouldn't be required to volunteer information, which seems to suggest that they wouldn't be asked a question at all.
So if you, my lord, if you go back to that 21, you'll see that that is something taken from X, as I've said, which we will look at, and it's again sort of it's reflected in 22. But what X contemplates, and all that the authorities look at it contemplate, is that there'll be sort of an initial. You've come back as someone we know was being returned, and we might ask you some initial questions. But that process is not where the Article 3 ill treatment risk lies. It's the second stage intensive questioning process once they've got you to, you're a hair trigger person, as in enough, we have enough now to think you're someone that we need to subject to more questioning. And that is what is talked about in that paragraph 22. And that refers back to the SSH country guidance case.
I'm sorry if I'm missing something, and it's a genuine. I may there's a lot I've got to read. I may have missed this, but I'm just speaking for myself. I'm not sure that any of the cases we've been shown so far addresses in terms what seems to me at least to be an obvious scenario that may arise, which is not that somebody will volunteer what they've been doing in the UK, or even be asked to volunteer, but that they will be asked the question: did you attend political demonstrations in the UK against the Iranian regime? Do the authorities help us on that?
I'm going to turn into BA, which is demonstrations, because XX is about Facebook. So that is in the bundle at 219. And again, the head notes on 220 are another helpful summaries for this. And I think particular head note 2 addresses my lord's question about what happens to people when they go back.
So just so I can be clear what your submission is, what do you particularly rely on, and what proposition do you rely on it for?
So the proposition that I advance is that it's accepted and it's found, and all these country guidance cases proceed on the basis that if you go back to Iran as someone who is being returned from the UK as a failed asylum seeker, you will be subject to a level of screening. However, the fact that you will be subject to that level of screening does not get you into Article 3 unless you can show that there is a risk that because of something they know about you already, or would readily get from you at that first stage, because, for example, which is not OM's case, you are very politically active and you're proud of it. And you're going to say, in which case you get into stage 2 questioning, which is, I think, accepted generally to be where the Article 3 ill treatment risk arises, because that is where, for example, torture might be used. And my lord, it's hard to sort of point you to the silver bullet in one country guidance case, because they do need to be read collectively.
Fair enough. Can I put something to you?
Yes, my lord.
And then you can tell me whether I've got it right or not. If we look at BA, page 220,
Yep.
paragraph 2, little paragraph C, last sentence. If information is known about their activities abroad,
Yes.
they might well be picked up for questioning
Yes.
and or transferred to a special court after they return home.
Yes, which is the stage 2 questioning I've proposed.
Sorry, is the submission you're making that we can infer from that if if before you land at Tehran airport, the Iranian authorities do not have information about your activities abroad, then you're not going to be picked up.
No.
Question.
Yes. That's what.
That's the submission.
Yes.
Right.
And that is what all the country guidance cases say.
But paragraph 2A says you are likely to be questioned if you've exited illegally, and it was accepted in this case that he was likely to be questioned.
Yeah. My lady, I'm not disputing that he will be questioned. And that is also factored in all the country guidance cases as well. Yeah. So they've all considered someone who is in the situation of Mr. Brown's client, and they've all found that it's not enough. Absent something wholly different from the normal run of cases to get you into Article 3. And he has not been able to point you to anything that distinguishes his client's case from the facts, particularly, as my Lord Singh pointed out, the facts of SS. They're literally the same. I appreciate my lady's point about the factual findings at the FTT.
I didn't actually say that. I said that's your submission.
Yes. Turning back into the country guidance case, and I think we've covered a lot of this ground already.
I'm sorry to go on about this point, but certainly I can see your submission that the fact that they're going to be questioned isn't enough to get into Article 3 territory. But is it enough to get into the question of whether the appellant would be expected to lie about having taken part in activities?
The question of what would they do when asked, if asked about it.
Yeah.
And my lady, you have my submission on the FTT decision in this
Which is
case.
that he would lie.
Yeah, because he's not genuinely politically motivated. He's acted throughout to bolster his ability to be in the UK when he has no legal right to be here.
So in other words, he would say,
Yeah.
no.
Yeah, he would lie to get what he wants, which was to get through safely. And I appreciate that I am now saying something that possibly the FTT should have said expressly. You have my submission on that. My learned friends just scoffed, which is not helpful. And I've made my submission on what I say you can take from the FTT's findings. So with demonstrations, we've looked at BA demonstrators, and my lord, it is a lengthy decision. I've taken you to the head note, but my skeleton argument, paragraph 15.7 sort of gives you more detailed references to the underlying paragraphs.
Sorry, I wasn't keeping up. Underlined paragraphs of what?
So just to sort of cover off country guidance on demonstrations.
Yes.
In BA,
yeah,
there are lots
yes,
of
I see.
underlying paragraphs to the head notes, and I've put the references in my skeleton argument for the court to digest in its own time. And then we get to the social media activity, which is XX, which we've talked about a lot, and just opening it up again at the back of 13. Apologies, my lady, you don't have tabs. You have told me that. It starts at 507. And we've looked at some of these head notes before, but in terms of head note 2, which is on 508, you have an explanation of who is the kind of person who would still be at Article 3 risk even if they did delete their Facebook activity. And it's not disputed that that would include people who had engaged in political activity that was not genuine. And the key point, as I've submitted before, is knowledge of...
Which paragraph?
So sorry, this is head note 2 on page 508. So the key question is, how likely is it that the material has come to the attention of the Iranian authorities such that deletion of the Facebook account or the posts wouldn't remove that and then, you know, allow you to be returned without giving rise to an Article 3 risk. And then head note 3, the fact of a returnee not having a Facebook account or having deleted it will not as such raise suspicions or concerns on the part of the Iranian authorities. And then paragraph 4 talks about effectively what the first moment at which someone might be scrutinised by the Iranian authorities, which is when they are applying for emergency travel documentation. So while obviously today we've focused on what would happen once you've actually got back to Iran and you're physically in the country, it is accepted that there is an earlier stage of assessment by the Iranian authorities. So when you're sort of first drawn to their attention. And then we have in particular 6. The timely closure of an account neutralises the risk consequential on having a critical Facebook account, provided that it was not specifically monitored prior to closure. So that's someone who's already come to the attention of the authorities. And then turning over the page onto 510, we have head note 9. Which goes to the point, the HJ Iran principle, and what you should do about it when you're looking at the Facebook account issue. And my lady, you could read that in full, I'd be grateful.
Does it come down to this, that actually there are circumstances in which it is entirely realistic to predict that a person will lie when interrogated at the
Yes.
airport? What HJ Iran says you can't expect them to lie about is, for example, their sexual orientation.
Yes,
The
because
reason for that is, first of all, they are in fact gay,
yes,
and secondly, that's a fundamental right.
yes,
The whole purpose of the Refugee Convention is to protect people's ability to express their sexual orientation
Yes.
freely. And I think what they're doing, but please help me if I'm wrong, in this paragraph, head note 9, what they're doing is drawing a contrast between that which is a fundamental right protected by the Refugee Convention and something else. They don't quite come out and say this, which is why I asked the question. Are they, in effect, saying that it is predictable that you will lie about other things?
yes. I think that the key thing here is, so in HJ, it was about sexual orientation, my lord, as you say, and it was, if you could say, oh well, if you go back to Iran, you could just lie and it would be fine. And obviously it was found that no, that's not an automatic bar to an asylum claim. There obviously is the nuance after that of if someone would conceal their sexuality because of reasons that are not to do with fear of persecution by authorities, that won't help them. But if they are, as analogous to this situation, concealing it from authorities and having to repress a key part of themselves to not be persecuted, then requiring someone to do that would make a mockery of the convention. Because you'd say, well, you have to count out the persecution and lie. But in this case, they're saying, we're asking you to delete a Facebook account and not volunteer that you posted on it in the past. That's different from being asked to lie about your political beliefs, which is what they were looking at in RT.
Yeah, but if they ask the question, have you deleted Facebook accounts?
Yeah.
You can be expected to lie about that.
You can, but if you look back, my lord, at head note 3 in XX, you'll see that the fact of having deleted an account, it was found, will not raise suspicions or concerns. So if you were asked, have you deleted it, and you said yes, that's, and if they could see that you had, obviously. So the key underlying paragraphs that inform those head notes are 98 to 102 of XX, which are on page 538, and I believe the court's read them in full earlier, so I won't ask you to do that again. Checking. And yeah, the particular point is the one I've just been discussing with you, my Lord, Lord Singh, paragraph 100 and 102, which again you've already looked at, about where someone's found not to have been acting on genuine political beliefs. It won't be a human rights violation to hold that they can be reasonably expected to delete their account and not volunteer information about it. And there's reference in it to the principle in HJ that the court should obviously not be swayed by assertions by someone wanting asylum that they will act in such a way as to achieve persecution. And that's para 88 of HJ, which I won't take the court to, but it's on in the authorities bundle at 54. And obviously the court found, tribunal found in this case, that we were talking about someone who had been disingenuous, and adverse credibility findings were made against OM, which are not appealed. And the court's already looked at SS, but the approach in PJAC, in XX PJAC, was approved expressly. And if we look at paragraphs 42 and so on in particular, so that's starting at page 154 of the authorities bundle. My lords, I think to save time, I'd invite the court to read all SS in full, but these sections in particular, and in terms of
all of this is focusing on Facebook, and you've taken us through the findings of fact in relation to Facebook. To be fair, Mr. Brown doesn't actually rely on Facebook.
It's the same. It's the same issue in demonstrations and in social media. The question is knowledge. You assess how the Iranian authorities might become aware of activities, and then
there's nothing
you go
in
on
the
from
country
there.
guidance to suggest that somebody with the profile that OM has will be asked, have you taken part in any political activities in the UK?
No. It's found in BA. So the big difference between BA and XX, why you need the two sets of country guidance, is obviously social media is a different kind of political activity. It exists in a different space, and it's effectively a higher threshold to get yourself noticed by the authorities, because they have to delve into the internet to find you, whereas with demonstrations you're standing, in OM's case, outside their embassy, and that's much easier for them to sort of see and identify you. But the fact of that is not enough, because they have lots of protests, and BA sets out sort of what you need to do to get on their radar, which is effectively the same. But no, neither BA in terms of demonstrations or XX in terms of social media say that someone in the position of Mr. Brown's client will be at risk of Article 3 ill treatment just because of the facts that have been found in his case. And I would encourage this court to read them both in detail. They are long, so I've not been able to take you through them in detail, but the relevant paragraphs are in my skeleton argument. So in going back to SS, so the paragraphs in particular where this court approved the approach in XX are 42 and 154, 44 and 155, and 54.
Sorry, 42, 154.
44, 155, and 54 to 56, which my lord, my lady, you've already seen today on 158. And in respect of S more generally, 54 to 56, my lady, yes. So they're the ones we looked at previously. In respect of S more generally, as I've said in my skeleton argument, this decision approved the approach in terms of the country guidance decisions, so the approach taken by the FTT. And as I've said in response to a question of my Lord Singh, it's my submission that it's all square on the facts. And I've given you the relevant paragraph. So I've probably already made most of the submissions I'm going to make in respect of the grounds of appeal specifically, the focus of which has obviously shifted from just head note 10. I'll just have a quick check to see if there's anything else I need to say. Oh, so there are two cases that my learned friend has put in, one of which is expressly referred to in his skeleton argument and the other of which is in the authorities, but he hasn't taken you to it today. The first is the case of D8, which is a SIAC case expressly referred to in the grant of permission and in the skeleton argument. My short submission on that case, and it's at page 160 of the bundle, and I'll give this court some key references, is it doesn't assist because it shows the commissioners applying the same country guidance principles to dramatically different facts. So it's clearly distinguishable. And footnote 24, paragraph 21 of my skeleton sets out all the ways in which it was factually distinguishable. For example, D8 had been the beneficiary of asylum status in the UK, he'd been imprisoned there, and he'd been identified, most importantly, as a threat to UK national security, and the Iranian authorities have been asked about him. So it is very different, and also importantly, the commissioners held that there was evidence that the Facebook account was publicly available. In this case, the FTT said no, there is no evidence, and actually, it didn't feel it had sufficient evidence to assess what D8 would reasonably do on return. It said, and this is, I won't take you to it, paragraphs 165 to 166, we don't know enough to say whether he'd delete his account or engage in political activity or not. So that does not assist at all. And then I'll deal with, it's a case of FA, and that's at tab 5. And the reason I deal with this, despite Mr. Brown not having mentioned it, is because it's a Court of Appeal case about returns of an Iranian Kurd. So that's page 126.
You may remember that my lord was in it.
Oh yes. Sorry, my lord, apologies.
I think I gave a one-sentence judgment.
It was more than one sentence, for sure. It runs to several.
But my lord's was the one sentence, I think.
Yes, I agreed.
I agree with both judgments. Yes. No doubt that the contribution was more extensive than that. But the key thing on FA is that it was a pre-XX case. So is an illustration of the difference that XX has made in terms of the approaches of the UT to this issue.
Is that right? Is it pre-XX?
So it was decided artificially without the benefit of XX
see.
because XX
Yes,
was not handed
yes.
down at
Yes,
the time of the
yes.
FTT's decision.
Yeah.
So the error of the UT was the UT said,
Yes.
well, the FTT was right
Yes.
because XX says
So
that
it's
actually
deemed
couldn't have
to
done
be
that.
pre-access.
Yes. So it's an artificial situation. So you need to look at it with that in mind. We're obviously a post-XX court. So that's the first point. It did, however, approve all the Upper Tribunal country guidance cases before XX. So that's BA demonstrators, SS and HR, which is about illegal exit, and HB, which is about returns of Kurdish nationality. So another instance of those cases being approved by the Court of Appeal. And I won't take you to them, but those paragraphs are 53 to 60, starting at page 136. And the second point I'd make is that it's clearly distinguishable on the facts because the Court of Appeal held in that case that the FTT had failed to carry out a proper assessment of the Facebook material or to explain their finding that the material, if seen by the Iranian authorities, would not be sufficient for the hair trigger approach to apply, which the Court of Appeal found questionable given the limited information which was described. And I would suggest possibly that looking at what the Court of Appeal in this case said about the quality of the FTT decision making shows you an example of where you can have doubt as to why they reached a decision and why the Court of Appeal was willing to overturn it and send it back down to the FTT. And my submission is obviously in this case we're not there, while it's not expressly dealt with the question of would you tell a lie, there is enough to show that that matter was in the mind of the FTT and it was dealt with, albeit implicitly. My lords, my lady, unless I can assist further, those are my submissions.
So just so I'm clear, you say on the findings of fact made by the FTT, the Iranian authorities would not immediately proceed to a second stage interrogation.
No.
There would, regardless of that, be some screening on arrival.
Yes.
But you say it is to be inferred that the FTT thought that what might be asked or what might be said in response to questions would not be enough to take the appellant to the second stage.
Yes. In circumstances where they didn't already know about his surplus activities in the UK.
Yes, I see.
And I should probably close by saying that even if it's held that the FTT didn't directly address itself to that question in paragraphs 37 and 38, it would not, as the UT found, have been material, because on the facts as found which are not appealed and applying the country guidance test, you would come to the same outcome.
Why would you come to the same outcome? I mean, suppose that at the screening interview, the appellant, without even being asked the question, volunteered that he was he had taken part in anti-regime activities in Iran. How can we conclude that on that basis the FTT would have reached the same conclusion?
If he had been asked, what would you do? No doubt to bolster his asylum claim, consistent with all his other behaviour, he would have said, well, I'd tell them because I wouldn't lie to them. But that's not enough, because he's an individual who's been found to be lacking in credibility, and HJ says you must treat such assertions with a huge pinch of salt, and that's paragraph 88, because you will say whatever you want to say to get through to Article 3.
I see. So you're not saying that had he said this in Iran, it would have made no
No,
difference. But
that's not the
were
question.
he to say it to the first tier,
Yes.
the first tier wouldn't believe him.
Yes. My lords, my lady, thank you.
Mr. Brown.
Briefly, my lady, my lordship, the central issue about issue 1 is whether the question was asked. I would distinguish what the judge at first instance did in this case to what happened in S. In S, there was what was satisfied that the judge had asked the question, and it was reasonably likely that the defendant would not volunteer the information. So I draw that distinction. So it can't be on all fours. Second observation is that I think BA wasn't a case involving someone of Kurdish ethnicity. My last observation, although it may not make a difference, is that in XX, the case succeeded. Interestingly enough, it succeeded if you take it to 543. 119. That's the general observation. 119. It succeeded even though the tribunal was satisfied it was a tried claim.
My lord, could you please read paragraph 118 as well?
So
On
your
page
joint
542.
request is to read paragraphs 118 and 119.
Yes.
Yeah, let's do that.
I don't take them out any further. Thank you.
Just hang on while we read them. Thank you both very much for focused and helpful submissions. We're not going to give judgment here and now. You will be supplied in the normal way with the judgment in draft, and we'd be grateful if at that stage you would seek to correct our English and typing. That won't, of course, be an opportunity to re-argue the case. At the same stage, could you please seek to agree an order dealing with consequential matters? If there are points on which you disagree, could we please have brief written submissions, and we would expect to settle the points in the order that we make. Lastly, though, I imagine you're already well aware of this, all those involved should bear well in mind the embargo and the importance that is attached to compliance with it. I think we've already had a list of those who you think that the draft judgment should go to. Is that not
Don't
right?
believe so, my lord.
In that case, can we please have a list of those to whom you think the draft judgment should go? And if at any later stage before the judgment comes out, you think of anybody else who the judgment ought to go to, can we please ask you to come back to us? Because, of course, revealing the contents of the judgment without permission would be a contempt of court. But thank you both very much for your helpful submission.
Court rise at Able.